Hi, I'm Martin Quodbach, working as an attorney at law in Germany, Cologne. I'm working with invention matters and employees inventions. And you're listening to IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 87 of IP Fridays. Today's interview guest is Martin Quodbach, one of the very few experts who really knows the Employees Inventions Act in Germany, the law defining the remuneration of employees for their inventions. And this will be very interesting for all the patent professionals among the listeners. But before we jump into the interview, I have some news for you. First of all, I want to tell you that the EU has published a position paper on their wishes post-Brexit. So what they would like to see after a Brexit. And from the position paper, you can see that the negotiations will be tough. The EU demands that owners of existing EU-wide IP rights, like European patents or like EU trademarks, should post-Brexit automatically have a UK equivalent IP right for no additional financial costs and with minimal administrative burdens. And if such UK protection requires new UK legislation to create or recognize such a right in the UK, that needs to be in place at the withdrawal date, at the Brexit date. Another point is that for EU-wide IP applications, which are pending at the time of Brexit, the applicants should be able to seek protection in the UK from the same date as their pending EU application to ensure no rights are lost. And as a last important point, any IP rights which are exhausted, meaning IP owners cannot object to further commercial activities in the EU before the withdrawal date, should remain exhausted in both the UK and other EU member states. I took this information from a great article on lexology.com dated September 7. The next thing is about the EU IPO, the EU Intellectual Property Office. As many of you might know, as from 1st of October 2007, there will be a lot of changes regarding trademarks, EU trademarks. And I want to briefly summarize the main changes. First of all, the rules regarding graphical representation changed. So graphical representation is no longer a requirement for trademarks, so you can submit sound trademarks, motion trademarks, multimedia trademarks or holograms, also with MP3 files or with MP4 files. And shape marks can be submitted not only with JPEG files but also with OBJ files, STL files and X3D files. Also, a new trademark type will be introduced starting from 1st of October, the certification mark. In essence, a EU certification mark relates to the guarantee of specific characteristics of certain goods and services. The certification mark is defined as a mark that is capable of distinguishing goods or services which are certified by the proprietor of the mark in respect of material, mode of manufacture of goods, or performance of services, quality, accuracy, or other characteristics, with the exception of geographical origin, from goods and services which are not so certified. The regulation of use constitute the essence of the certification mark. These must be filed within 2 months of the application and need to contain, in particular, 3 things. First, the characteristics of the goods or services to be certified. Secondly, the conditions governing the use of the certification mark, and thirdly, the testing and supervision measures to be applied by the certification mark owner. One very important point is that the owner of a certification mark is precluded from using the mark for the certified goods and services. And then there are some procedural changes. One of the most important changes are the changes regarding priority. The priority claims must be filed together with the EUTM application, and the documentation in support of the claim must be filed within 3 months of the filing date. The priority claim is no longer examined in substance, and it remains as a mere claim until it is relied upon and it is necessary to validate it in proceedings. Then there is a change regarding the acquired distinctiveness as a subsidiary claim. Applicants will have the possibility of invoking Article 7.3 as a subsidiary or alternative claim either at the start of the application process or later. The advantage of a subsidiary claim is that it only crystallizes if there is a negative final decision on inherent distinctiveness. This allows the applicant to exhaust its right of appeal on inherent distinctiveness before it is required to prove acquired distinctiveness. This will mean that the users do not need to incur the expense of gathering and presenting evidence of use unless it is necessary. Then there are some formal changes regarding opposition and cancellation proceedings. They are basically brought in line with each other, and the grounds have been reordered for clarity. One other change that makes lives of trademark owners much easier is the online substantiation. So you no longer have to file copies of the registries, of the register details of trademarks that you, for example, invoke in opposition proceedings, but you can actually file a reference to these trademarks, for example, a URL to a TM view result in a search. Then there are changes regarding languages and translation. As of October 2017, most types of evidence can be continued to be filed in any official language of the EU, but where the language used for evidence of substantiation is not the language of the proceedings, a translation will now be required only where requested by the office on its own motion or upon recent request by the other party. However, evidence for substantiation, for example, certificates of filing, registration, and renewal or provisions of relevant law must still be submitted in the language of the proceedings or translated into this language within the time limit set for substantiation. One other change in the EUTM rules is about the assignment of EUTMs, EU trademarks, where an agent or a representative registers an EUTM without the proprietor's authorization. The proprietor is now entitled to demand the assignment of the EUTM, and previously the remedy for the proprietor under the EUTMR was to invalidate the EUTM, so this must be much easier now. Then there are a lot of changes regarding the communication with the office, the EU IPO. So you can no longer hand deliver things or deposit things in a post box at the office, but you can still use a courier to deliver any paper. As of 1st of October, fax is defined as an electronic means, so fax is no longer explicitly mentioned, but it is assumed that fax is electronic means. As of 1st of January 2018, fax will no longer be accepted for filing EUTM applications or renewals. And then there are some minor changes regarding the rules for the boards of appeal and some transitional rules. So now let's jump into the interview with Martin Quodbach about employees' inventions in Germany. I'm very excited to be joined by Martin Quodbach today. If you don't know who Martin is, he is one of the very few experts in the field of Germany Employees Invention Act. That is the act for remuneration of German employees for their inventions. And he's also attorney at law for CBH Cornelius Bartenbach Häsemann and Partner in Cologne, my own hometown. And his office is only let's say not very far away from our office. So thank you very much for being on the show, Martin.
Yes, thank you, Rolf, for your invitation. I really appreciate what you're doing.
So most of our listeners are probably not familiar with the Germany's Employees Invention Act. Can you briefly summarize the main goals and what is important, for example, for US companies? Most of our listeners are from the US, so maybe you can focus on their issues, let's say.
Okay. So to understand the law, I think it's good to take a view back in the history, because our special law has a quite long history up to now, over 70 years now. The first idea was to create an incentive for employees to make inventions. And the second motivation, and so a very important motivation, is that the constitutional law requires a compensation for the transfer of rights from the employee to the employer. So the constitutional law says that intellectual property is a part of the property that is secured by the constitutional law. And the German Act wants to balance the mutual rights and obligations. On the one hand, that the employee loses his rights, and on the other hand, he gets a consideration in form of the remuneration claims. Let me just summarize the main elements of the law. The law covers so-called service inventions, and this service invention can either be an invention in a so-called obligatory invention, meaning that the employee works in his field of contractual field. For example, an employee who works in a research and development department, and he owes to seek for inventions. And on the other hand, we have so-called experience inventions, that are inventions that are based on experience or activities of the employee. And to give you an impression how these terms are handled in the practice, in fact, there's only a very little invention that are not service invention. You always find a hint to define at least an experience invention. So in practice, free inventions are very seldom. The law, in principle, the law stays with the basic principle that the owner of an invention is the inventor, and then the law becomes relevant, saying that the employer can claim for service inventions. And in principle, that requires a formal claiming via a textual form. But we have since October 29, we had a change in the law that says as long as the employer does not release the invention in textual form, the employer can still claim the invention. Before 2009, we had several problems with this transfer of right, because the old version of the law required a written declaration by the employer saying he wants to claim the invention, and there was in 2006 a decision of the German Federal Court, so-called Haftetikett case law, meaning if you translate it, a sticker case. And this case law says that the due time for claiming the rights in the 4-month period has become into force by applying for patent application when naming the inventor as an inventor before the patent office. And in cases where both parties, so the employee and the employer, did not know about the law, there were the fact that the employee invention became free because the employer missed to claim the invention in due time. And actually, we still have to handle such old cases because every invention and patent application filed before October 2009, let's say June 2009, because of the 4 months period, is still relevant in the future, certainly. I think we work on these cases at least 10 more years from now. So that is the basic claiming and the transfer of the right as one issue of the law. And certainly I mentioned we have the claim for remuneration. And in section 9 of the law, we find this claim for reasonable remuneration, but the law itself does not say what is reasonable and what is not. As a second regulation, we have these official remuneration guidelines that in fact did not pass the federal parliament, but was only published by the Ministry of Labor already in 1959. So the act was the formal act was from 1957, and these guidelines are published in 1959. And in this remuneration guidelines, we have several provisions ruling the calculation of the remuneration claim, but I think we can come to this point later. And further, the law comprises some formal rights of an inventor. Section 13 rules the right or the duty of the employer to file a patent application after getting an invention report from an employee, and the employer is obliged to file it in due time without any delay, meaning always an effort, paying a patent attorney to draft such an application, and sometimes it is always a financial burden because maybe there are some other thoughts and patent strategy to wait with such an application, but the law is quite clear in that point that the employer actually does not have the liberty to do what he wants. And we have some further formal rights and obligations saying that the employer has to release patent applications in foreign countries if we don't want to seek for patent protection in such countries. And also the employer has to release and transfer applications that he does not want to uphold. And last point in the law is that it's very strictly in favor to the employee, because the parties are strictly bound to the law. Section 22 says that there is no waiver to the detriment of the employee before an invention report, and Section 23 protects the employee against agreements that might be a detriment for the employer, and Section 23 requires that agreements have to be equitable, and as long as, for example, there's a thumb rule, the compensation claim is less than 50% of the claim that's covered by the law, the respective agreement is invalid.
So now we have an overview of what the law encompasses really and what the law is all about. But what would be the most crucial points in practice when handling the law by an employer? So what should an employer do to abide by the law, basically?
I can answer this question against the background of our daily work. So to say, about 50% of our cases are disputes about the reasonable remuneration. So there's litigation, and there's also a possibility to go to the arbitration board at the German Patent Office in order to find an amicable solution between employee and employer. That's one big issue always, and then, as already mentioned, we have problems with the transfer of rights in old cases before 2009. And certainly there's also there are a lot of matters where we advise clients with regard to remuneration question and incentive systems. I think maybe that's a point we can come to that later. But all these agreements on the rights and duties covered by the law have to be assigned after the invention report, as already mentioned, because the law is quite strict in this matter.
Now we heard a lot about remuneration. I mean, the money that actually gets transferred from the employer to the employee. What would be a typical remuneration to be paid?
It's quite hard to answer it in an abstract way, because certainly it always depends on the single case. The remuneration guidelines are based on the principle that the remuneration has to follow the principle of monopoly, saying the employee has to be compensated for benefits that the employer drives on basis of the patent protection. So if the patent can be exploited, then the employee has to get a part of these benefits. The remuneration guidelines comprises a lot of quite mathematic formula how the remuneration has to be calculated. And the basic formula is that the economic value of the invention has to be multiplied with the so-called participation factor. It's a little bit hard. It's not easy to translate these technical terms in the remuneration guidelines. So economical values is a technical term for us and for me, and also this participation factor. And certainly the remuneration also depends on the way of exploiting the invention. For example, making a turnover with patented products, one possibility, one way to exploit invention, but we certainly can also have benefits in form of licensing contracts, so licensing and royalty incomes. And inventions certainly also can be sold to a third party, and the purchase price must be the basis for calculating the remuneration. So the economical value, as a technical term, asks what would be the market price for the invention. And we consider the view of rational and reasonable parties that would be, for example, license the invention to the market. And if we have come to such an economic value, we have to ask what is the personal participation factor of the inventor. That term must not be mixed with the inventor's portion or inventor's share in the invention. That certainly is a known factor. For example, if an inventor that only has a contribution to the invention of 50% does not get the same as a whole inventor. The personal participation factor depends on three sub-factors. And the first factor is how close was the inventor to research and development activities. So was he hired for making inventions? The second sub-factor asks the history and solution of the invention. Was the invention derived from know-how and technical assistance that was that he had access to? And the third sub-factor asks the position and in the hierarchy of the employer. So, for example, an unskilled worker in a workyard solving a problem which is complete outside of his background gets personal participation factor maybe up to 100%. And on the other hand, we have a head of a research and development department that at the end just can claim for a personal participation factor of 5 or 7%.
Mm-hmm. But now we know how the remuneration is calculated, and you quickly avoided my original question, right? So how much money actually is transferred from the employer to the employee? Let's say we have an example. In an example, we have a product has a turnover of 1 million euros revenue per year. And there would be a sole inventor, just only one inventor. What do you think? What would be a typical remuneration for in such a case?
Okay, in that case, we would base the remuneration on the royalty consideration. So the license energy would be the predominant calculation method. And then first we have to ask if the invention was already subject to a license contract. In that case, this license contract sets the measure also for the calculation. If we don't have a concrete license contract, we ask license contracts in the technical field and what royalty rates are common in this field. For example, if we can assume a royalty rate of 2%, and then we have to ask if the product is completely covered by the invention, or if maybe it's only a part of the product. So we call it determining the correct technical reference value of the invention. But when we assume the whole part is protected, then we can calculate, as said, we take the 1 million turnover and multiply it with a license royalty rate of, as said, 2%. Then we have the invention value, would mean 20,000 euro. And then we have the next step in the calculation, the personal contribution factor. Certainly we would need details of the single case, but for example, if we consider a member of a research and development group, so an engineer, then I would assume his personal contribution factor about 10%. And that would lead to remuneration of 2,000 euro based on a turnover with 1 million euro.
Great example. So now we know how much money they earn. So it's typically not so much, and the employers will not go broke by paying the employees' inventions, their remuneration. And I think it's a good incentive to incentivize the employees to be creative and inventive. What do you think are the most important recent developments in the case law in Germany?
We're dealing with the law for 70 years now, so there are typical problems that are the same in the whole time and will keep the same, I think, because there's only very little chances of amendment of the law. So we expect the law to stay the same as it is for also the next 10 or 20 years. But one topic that is quite often discussed in the last years is a problem that the employer is not a really self-standing business in Germany, for example, but he is a part of an international group of companies. And the German law has only a very restricted view, or limited view when forming this regulation. And the law just is focused on economical advantages of the employer and only the company of the employer. But we can imagine if the employer is only part of a group, international group, then it may be not really helpful to just look at the benefits of this concrete company. For example, the company only does research and development services for a parent or sister company, and maybe the parent company really exploits the invention. Then the German law is really at the end of its possibilities. And for that reason, there are certainly attempts driven by employees to get access to the benefit of the whole group. And we have case law to that related to that questions, saying there is a possibility that the remuneration claim has to be based on the benefit of the whole group if either the companies of the group work in a division of labor, and or if they form an economical entity. And second question can be asked: how would reasonable parties of a license contract would react? What would be the outcome of such negotiations between these rational and reasonable parties, and what would be, for example, the basis for a royalty agreement? And that could also form a measure for our remuneration considerations.
But you don't mean the license between the group company and, let's say, the holding or something, and a small research and development company, but apart from that, let's say, that was like a different problem now, or does it play into the problem with the group and the small research and development company?
We would consider the hypothetical situation that a free inventor gets in contact with a employer, with the German company, and they would negotiate a license contract comprising also a right to use the invention in the whole group. Okay. And if this licensee would have forced the employer to pay for all companies and for the benefits and for the turnover of the whole company, then the German remuneration consideration would be equal to that.
So that is very employee friendly.
Yes. And we can go back to the beginning, saying that the employee has to be compensated for his loss of his IP rights that is protected by the Constitution. And that has to be equal and at least reasonable again. Always deals with the question of if the remuneration is reasonable or not. And again, so this background, coming back to your question, what are the recent developments, or what are kind of evergreens in our daily work? We have this idea of remuneration and incentive systems proposed by the employer. But as I already said, such systems can, or such such agreements, remuneration agreements, can be agreed upon after the invention was reported. The employer cannot implement such a system, for instance, in an employment contract, but from case to case, in every single case after filing of the invention report. And then we also advise companies in such remuneration and incentive systems that has to fulfill the requirements of the law especially regarding the section 23 of the law, saying that agreements are invalid if they're not equitable.
Okay, so we talked about the incentive systems and things to make the life of employees easier. So employers, basically. So what are the best ways to simplify the handling of employees' inventions with such incentive systems?
That's quite a big range of possibilities and models with different depths of regulations. First, one idea is often to agree upon lump sums in order to get a waiver from the employee with regard to his remuneration claims in the future. But this is quite complicated because of section 23 of the law protecting the employee from himself at the end. But one established element of such systems is a waiver of the employee of formal rights, as says section 13, 14 and 16, which mean a great burden for the employer. The employer always has to transfer rights that he doesn't want to continue. Right. Yes, and you can try to minimize these administrative burdens that are connected with this formal rights. And one further point in such remuneration systems is that are lump sums as really incentives. For example, incentives and lump sums in case of filing a patent application, or payment in case of granting of the first patent, or payment connected to the release of a product covering the invention. But mostly such payments hardly can replace an individual elevation, or they also can't replace a final remuneration according to the law. So mostly such payments in advance are only deductible against the remuneration claim provided by the law. One further point to be mentioned is that the employee has a quite detailed claim for information on the making use of the invention. And this also can mean a burden for the employer, and within such incentive systems, one can ease these claims and to make it more comfortable for the employer.
Mm-hmm. We have this employees' inventions system in Germany, and it's not very common in the rest of the world. Do you think that such incentive systems for incentivizing inventions with employees is a model for multinational systems like big, large corporations? Do you think they should in general or implement such rules?
Mm-hmm. We know such attempts, but it's always quite difficult. Certainly, we have a common basis. For example, paying incentives for inventions. I think that's a point that can also be agreed on for multinational systems. But the problem is that the Germany has a quite high and mandatory level based on the law, so based on the German inventors' remuneration. And if you try to adapt this level to all countries, then there's a danger of exporting special German problems. For example, with regard to claims for information and rendering account. So we advise clients not to lift the German level on the international level. At the end, mostly the German system will play a special role also in the future. So there's always incentives for the whole group, for companies, and special provisions for handling German employees' inventions.
Mm-hmm. So, Martin, that was a very interesting interview. We have learned a lot about the Germany Employees Invention Act. What would be the best way to get in touch with you if our listeners would have questions for you?
You're invited to go on our website, www.cbh.de.
All right. And people find you on the website, of course. So thank you very much for being on the show, Martin.
You're welcome.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.